Modern scholars and jurists have signaled agreement with the government's interpretation of the jurisdiction clause, the limited jurisdiction, Wong Kim arc, or both. As noted above, Professor Eyestreicher, a nationally renowned scholar, has written that reliance on Wong Kim arc for applying birthright citizenship to children of illegals is misplaced. Wong, by its facts and some of its language, is limited to children born of parents who at the time of birth were in the United States lawfully and indeed were permanent residents. As Professor Eyestreicher explains, the circumstances of Wong Kim arc differ from the unlawful immigration context. Wong's parents were clearly permitted to be within the U.S. at the time of his birth. A second respect in which the facts of the case differ is that, unlike for children of unlawful immigrants, there was no U.S. prohibition on Wong's presence at the time of his birth. His birth and presence within the U.S. was entirely lawful. And that distinction matters given that Wong Kim arc itself repeatedly referred to the importance of the sovereign's consent. Modern jurisprudence has likewise rejected the notion that the jurisdiction clause looks only to whether the child would be subject to the laws of the United States. The D.C. Circuit held just a few years ago that the concept of allegiance is manifested by the Citizenship Clause's mandate that birthright citizenships not merely be born within the territorial boundaries of the U.S., but also subject to the jurisdiction thereof. Oh, look, it's Hawk Tua. That's funny. Hawk Tua. And the evident meaning of the word subject to the jurisdiction thereof is not merely subject in some respect or degree, but completely subject to the political jurisdiction and owing them direct and immediate allegiance. Again, this makes clear that the question is not simply whether ultimate governance remains with the United States government, in other words, whether they're subject to our criminal jurisdiction, but whether there is a reciprocal relationship where the person owes total allegiance to the sovereign, which allows the person to be present. Judge Richard Posner, before he retired, this is the guy who went crazy. I've talked about him before. Judge Richard Posner, I believe it was torts. Torts is civil lawsuits. He wrote a textbook on torts that I had to use in law school, that I expect virtually every law school in the country made its students, its first-year law students, buy the Posner textbook. It was the seminal textbook on torts. He was a legal genius. He went on to get a seat on the Seventh Circuit Court of Appeals. He was probably, for Democrats, a front runner for a Supreme Court nomination. He's the one that made concealed carry mandatory in Chicago during that lawsuit. And he wrote the opinion, at least. And then Trump got elected, and Posner lost his mind, became completely TDS infected, and then he resigned from the Court of Appeals. And a few months later, within a year, it was revealed that he was suffering cognitive decline because of some form of dementia. So in his later years, he went quite crazy. But he was, for almost all his preceding career, considered a legal genius. Judge Posner, before he retired, also wrote about the jurisdiction clause, arguing that the interpretation espoused by the birthright universalists makes no sense. And he doubted it was correct even under existing case law because many aliens present in the U.S. owe no allegiance to the U.S. He noted that hundreds of thousands of foreign nationals have come to the U.S. solely to give birth, without the slightest hint of owing allegiance to the U.S. Quote, there is a huge and growing industry in Asia that arranges tourist visas for pregnant women so they can fly to the U.S. and give birth to an American. Obviously, this was not the intent of the 14th Amendment. It makes a mockery of citizenship. Subject to the jurisdiction thereof cannot mean subject to the laws thereof. It can't mean merely criminal jurisdiction. The historical record and both contemporary and modern scholarship demonstrate the jurisdiction clause looks beyond the simple question of whether someone is subject to the criminal laws of the U.S. There are additional reasons to reject the birthright universalist simplistic view. First, it would have been easy enough to say subject to the laws of the United States, but instead the drafters used a different term, subject to the jurisdiction of the United States, not just laws, but jurisdiction. That was intentional. And it invoked a term of art with a nuanced history and understanding, as we've explained. But the birthright universalists never provide an answer for why the drafters of the 14th Amendment did not use far simpler language if they meant only to invoke the simple concept of being subject to the law and not the jurisdiction, not the political jurisdiction. Second, the laws surrounding immunity further demonstrate why the Birthright Universalist interpretation is incorrect. They acknowledge the children of ambassadors and invading soldiers are not entitled to birthright citizenship under the 14th Amendment, but they're wrong to contend that this was because those groups are supposedly immune from U.S. law. Federal law does apply, at least in part, to invading soldiers, and even more obviously, to their newborn children who would not be enemy combatants. And U.S. law also applies to most diplomatic officials, as only a narrow set has anything approaching full immunity, which itself can always be waived case by case by the home country. So, when it comes to diplomatic immunity, the ambassador, the actual individual ambassador sent to the U.S. by a foreign nation, that guy or gal gets pretty close to absolute immunity from U.S. law. Can't do a darn thing to him. But all his subordinates have a much more limited form of immunity. They don't have absolute immunity. For example, it was a big problem in New York City for many years when I was living there in the 70s and 80s. Parking in Manhattan, as you might imagine, is horrific. And then you have the UN building. And all the people in the UN, they would just double and triple park. They would block roads. They would leave their car wherever they wanted. And then they would say, well, you can't even give me a parking ticket because I have diplomatic immunity. So the federal government passed a statute that says, no, we don't care what you have. If you get a parking ticket in New York, you got to pay it. Otherwise, New York would have been unmanageable for driving. So limited immunity, even for diplomats and consuls. Furthermore, there is no diplomatic official who is fully immune from all forms of civil liability. You can be civilly sued, for example. There's no logical reason why ambassadors' children would receive greater immunity than their parents. The opposite is far likelier. This means none of the Birthright Universalist examples hold up. Every type of person they list as falling within the jurisdiction clause is already subject to at least some of the laws of the U.S., and they could be subject to even more laws on a case-by-case basis. At best, they have qualified, partial, or contingent immunity. The Birthright Universalists have no way to explain how individuals who are clearly subject to at least some of the laws of the U.S. are nonetheless not subject to the laws of the U.S. The answer is that the Birthright Universalist test is just the wrong one. Third, the Birthright Universalist interpretation proves too much. If qualified, partial, or contingent immunity were sufficient to render diplomatic officials not subject to the jurisdiction of the United States, then domestic officials who receive such immunity, like judges and prosecutors, would likewise not be subject to the jurisdiction of the U.S., and their children, would not be citizens under the 14th Amendment. That is wrong, of course. And the reason is because domestic judges and prosecutors, unlike ambassadors and invading soldiers, have total allegiance to the U.S. and are present with its consent. They are therefore subject to its jurisdiction, political jurisdiction, and their children born or naturalized in the U.S. are U.S. citizens. For all these reasons, as this Supreme Court held over a century ago, the touchstone for birthright citizenship under the 14th Amendment is total allegiance to the United States rather than being subject to its criminal laws or some subset thereof. Conclusion: for the foregoing reasons, the amici urged the Supreme Court to grant the petitions and reverse the lower courts. Insane, progressive fascist, unelected, black robe, tyrannical, inferior district trial court, and appellate court rulings on the birthright citizenship executive order.